No, Subhash Jha, I'm just getting in Subhash Jha because he has a contrary view to yours. Mr. Subhash Jha, has this been reduced to a WhatsApp hashtag? Is this WhatsApp talk, or is it the Vice President of India speaking like a politician more than the Vice President of, Vice President of India? I mean, how can you justify, Mr. Jha, for example, the actions of the Tamil Nadu governor, in whose context this entire judgment came? The man has been harassing the state government. The man has been sitting on laws that have been passed by the legislative. In one case, he's been sitting on a law for 3 years. The Supreme Court had to do something. This is an extraordinary case. They invoked 142. What is the problem? Now, us chakkar mein, if the Supreme Court of India has, in a sense, set a timeline for the President of India as well, what's the harm? कुछ गलत बात तो नहीं बोली ना?
Shreya, I feel that 142 or Article 32 is most often than not are grossly misused and abused by the litigants, and the Supreme Court falls prey to it. There is no reason for the Supreme Court to have entertained this petition under Article 32 filed by the state of Tamil Nadu. They could have very well said that, okay, it doesn't matter if this is the issue, you should have gone first to the High Court. There is a High Court of Madras available, and there is a bench also available in Tamil Nadu, apart from having the principal bench at Madras or Chennai. So therefore, the first and the foremost, the state government should have been relegated to the High Court. Why the High Court is bypassed, and why to entertain a petition under Article 32? And so far as Article 142 is concerned, the Vice President was absolutely right. Of course, I disagree with Mr. Sanjay Hegde. And to your question, that he was, of course, a politician. He was also a lawyer, and he is now the Vice President of India. So he understands, not that he is novice or he doesn't understand the technical or implications or legal implications of Article 142 or exercise of powers 201, 202, which has been interpreted. In my assessment, this is nothing but judicial activism and overreaching the process of law. You selectively make use of Article 32, you selectively make use of Article 142 and say that, oh, this is not a goat, but this is a sheep, or vice versa. This cannot be done, and according to me, this is an act of insubordination. Never ever happened in the history of our Indian judiciary that you comment on, you fix the timeline for the governor or for the President of India. Who are you to decide? There are several legislation, I may tell you, and I may remind my good friend Sanjay Hegde, there are several legislation in which the timelines are fixed. Now, the question which we should be posing to ourselves is whether those cases are decided by our courts during that lifespan within which they are required to be decided. And look at the manner in which the Supreme Court decides the special leave petition. In 93 seconds is the on an average time. Mr. Hegde appears in the Supreme Court quite often than me, so he would be knowing better. In 93 seconds, one SLP on an average is decided by the Supreme Court. Now, in this case, you went on to decide the issue which could have been very well relegated to the High Court and pass a long judgment and comment on the President of India and the governor. I mean, this is not how our courts should function. The court is nobody to tell the parliament or to the politicians, our politicians, legislature, as to how they should be functioning. The timeline is fixed, of course, as soon as possible is the word used, and then even in those statutes where the strict timeline is fixed. Say, for example, 138 of Negotiable Instruments Act. If I mistake not, 147 decides that within 6 months the cases should be decided. Yes.
Mr. Jha, are you telling me then it is perfectly okay for the governor who is not elected by the people of India to harass a state government that has been elected by the people of that state, keep them hanging, keep at least 12 bills that they have sent for your assent hanging, one of them for 3 years? That is okay. But the Supreme Court setting a timeline for the governor is not okay. आप देखिए तो बोल क्या रहे हैं?
No, I'm certainly against. Now, first and the foremost, I would not know. I may not be able to tell you as to why those bills were kept hanging. Out of 12, 2 were cleared and 10 were kept pending. Now, he may have his own reasons. Now, he may have his own reasons to give. But why to bypass the High Court and come straightway file a petition under Article 32 and the Supreme Court leaves aside all the matters? All other matters will be decided in 93 seconds. So in one of my videos, I've said that let us examine then those High Court judges who have been Supreme Court judges who while practicing as lawyers in different high courts, how many cases they have reported. I mean, is it possible, humanly possible, to understand the intricacies of a case in 93 seconds and you dismiss the petition in 93 seconds? And whereas you choose to write a judgment which runs into hundreds of pages. Now, I have a different view, Mr. Hegde. I have a different view so far as Ayodhya is concerned. If you have exercised Ayodhya in case 142 of Constitution of India, then the judgment should not have been running into more than 2 pages. In how many cases now we and myself and Mr. Hegde both are doing that hijab matter in Karnataka. We did it in Karnataka High Court.